Now would be a good time, if you're not muted, to go ahead and mute your microphone, because we are going to go ahead and get started. We're live on Facebook, and we are recording this lecture today. So just want to let everybody know that Laura is going to post a few links in the chat. So if you are not yet on our email and you would like to get weekly reminders about our Little Lunch lecture, you can sign up for email, make a donation if you like to support this program or other coastal land trust programs, and just generally keep in touch. So let's see, what else? Oh, did I say hello and welcome? My name is Stephanie Boret. I'm the Director of Donor Relations at the Coastal Land Trust. It's been a couple of weeks since I've been with you guys, and so I have completely forgotten how to do this, apparently. So we're glad to have you today. Mavis Gragg is joining us today. Mavis is a seasoned attorney and conservation professional, currently serving as the Director of the Sustainable Forestry and African American Land Retention Project at the American Forest Foundation. Say that 3 times fast and you win a prize. Prior to this role, Mavis founded the Gragg Law Firm, PLLC, in which she assisted clients in estate planning, estate administration, and heirs property matters, which she will speak about with us today. Mavis also serves on the board of the directors for the Triangle Land Conservancy and is a member of the North Carolina Parks and Recreation Authority. Mavis, thank you so much for taking the time to be with us today. I'm sure we have a lot of new things to learn, so I will let you take it away.
Thank you very much, Stephanie, and hello, everyone. I'm very excited to be here, one, because I love coastal land trust, and I love talking to people about heirs property, and I'm excited that you are providing an opportunity for your constituents to learn about heirs property. So yeah, I will share my screen. I have broken the presentation rules, and I have 22 slides for 30 minutes, so please don't judge me. So basically, I wanted to make sure that you get a full picture of what the issue is and why we should care about it and what we can do about it. Stephanie already shared a little bit about my background, but I am basically an attorney who has dealt with death and dirt all of her career. I also have a background in mediation and a deep appreciation for intergenerational wealth, particularly that centered around the land that's centered around wealth that's centered around land and families who are land rich, cash poor. And so that's why I've approached this work and never imagined that it would take me to a forestry organization, but this project, the Sustainable Forestry and African American Land Retention Project, is a really unique program that's using natural resources as a way to support landowners addressing legal issues related to their ability to keep their land. And we're going to learn more about why those legal issues exist and how they are addressed. So we'll talk about the origin of land loss issues and heirs property. We'll talk about some initiatives that support heirs property preservation and the economic and green incentives to addressing legal challenges related to heirs property. But first, let's talk about what heirs property is. So there's no legal definition of heirs property, but it refers to land that's owned by multiple people, each of whom have inherited their share. So you simply have to be an heir who's inherited property from a family member and own it with other family members. Doesn't matter if you inherited it through a will or from someone who didn't have a will. So I'm curious, for those of you on the call, how many of you own heirs property? So Stephanie has put up a poll, and we'll give you a few seconds to input whether or not you own heirs property. Owning family land with other family members. Okay, so far, half of the group owns heirs property. I own heirs property as well, so we're in that group together. All right. Yeah, so about half of us own heirs property, half of us don't. We all have the opportunity to create it and create issues around it. And so for those of you who don't have heirs property, certainly this will be a way to incentivize you to make sure that you continue not to have the legal challenges related to heirs property. So We know that heirs property refers to land owned by multiple people. Let's talk about the legal issues related to heirs property. First, I think it's important for us all to appreciate how ownership of land transfers. There's two ways to transfer ownership of land. You can use a deed, which is this first image right here. Oops, that I moved away from. A deed is a legal document in which the person owning the property says, hey, I, Mavis Gragg, own this property, and I'm transferring it to Chris Pickler. And then you would have a legal description. I picked on Chris because he's on the call. You have a legal description, and then the grantor signs the document, and it's recorded in the Register of Deeds, or should be recorded in the Register of Deeds. And then it creates a public record of the ownership. And then another way to transfer ownership of land is to die. If you die owning land on your date of death, that ownership transfers to your heirs. Now, unlike a deed, there's no legal record automatically created. There's no document that is put in place automatically without some additional actions. You know, for example, if you have people with a will who own land, that will could serve as a record, but that will has to actually be filed in order for the public to be put on notice. And then in America, most people do not have wills. And so usually we're relying on transfers by what's called intestate succession, which we'll learn about later. And so again, all you have to do is die, the ownership transfers, but it's not creating a record of how the ownership is transferring. And that particular aspect is one of the challenges of heirs property. So land does not begin as heirs property. In fact, it begins as being owned by an individual or a couple. And in our case, let's say today that we are talking about family land where a couple has purchased 40 acres of land and they're married, and it's in North Carolina in the region of the Coastal Land Trust. And let's say that for illustrative purposes that our couple has 4 children. The fourth, or the husband, let's say the husband passes away, we'll pick on the men, the husband passes away, because they're a married couple, the ownership will then transfer to the wife. That's because our law has an inherent right for married people owning land together for the property to transfer to the surviving spouse. And let's imagine that our surviving spouse has passed away and we have, who are the heirs? In this case, because this person only had 4 children and was not married, then the ownership of the property would go to their 4 heirs. So in this scenario, poor Stevie is with Michael, Sammy, and Aretha. Probably should change them to living people, but they each get a 1/4. Now, something that's often confusing to heirs property owners is what do they get a 1/4 of? Under the law, they get an undivided interest in the land. So in this case, we have 40 acres. They're not each getting 10 acres. Instead, they're each getting a 1/4 share of the entire 40 acres, meaning that they're all entitled to use the 40 acres. They're all entitled or responsible for the 40 acres, and they all have joint decision-making power in that 40 acres. And if you think about how families grow, the ownership of this family land being passed from generation to generation will also grow along with the family tree. So this gives us an example of how a family tree can expand over the course of multiple generations. At the top in the black boxes, we have our original couple, and then they had 4 kids. That's that next purple row. A few of the kids got married, as indicated by the yellow boxes, and then they all had children, and some of them had grandchildren. Now, many of you may have heard about heirs property, and the framing of it has often been in a very negative context. It's viewed as a very complex legal issue that is resulting in a lot of loss, is resulting in undermanaged property, but there are a lot of benefits to heirs property, and I think it's important for us to view it as family-owned land. And family-owned land is really important, especially in the conservation realm. And this practice of passing ownership from generation to generation is practiced around the world. In Bougainville, not sure if any of you have heard of Bougainville in the South Pacific, that is a small island nation, and inheriting family property is a right, as a birthright. So family land is passed from generation to generation as a right. The same practice and value is also in East Africa, in Tanzania, in West Africa, in Ghana, and of course here in the United States. again, many of you may have heard about heirs property, and the framing is often in the context of loss of land, of heirs property owns land in the southeastern United States, particularly in the African American community. Perhaps you've also heard of it in the context of the Appalachian Mountains. A lot of land in the Appalachian Mountains is owned as heirs property, but it exists across the country, and the notion of having intergenerational family land ownership is a highly appreciated value around the world. It's just the legal challenges that make it complex and difficult to manage. So let's go back to our family tree. Now, again, this is the same family tree. A little bit, the colors are a little bit different, but we have our original 2 owners. We have our 4 children. The yellow boxes are spouses, and then the peach boxes are grandchildren, and then what is that color? Periwinkle is as great-grandchildren. Now, based on your understanding, we're going to do our second poll question. Based on your understanding of how our laws work, and assuming that none of the family members had wills, so we're relying on the set of laws that exist when you don't have a will, how many owners do you think we have in our family today? And note that the X's indicate that the people are deceased. So several of the family members have passed away. Based on your understanding of the law, how many owners do you think we have? And you will not get penalized if you don't get it right. All right, we got some responses coming in. A few folks believe 10, 1, 16. Any additional responses? All right. So one thing that you're making clear with this poll is that we all have different understandings of who the owners are. And that mirrors in real life with families. Families often have different ideas of who are the owners and at what point do people become owners of the family land. And you're also illustrating with the different answers that it's really confusing. You know, imagine if we were a family and we were trying to decide to make some important action on our family land, and we had different interpretations or opinions on how that should be done. That can actually really lock people into conflict and prevent productive use of their family land. So what is our correct answer? Wondering if there's some attorneys out in the audience. But those of you who selected 16 are correct. And this has to do with the set of laws that apply. You know, again, we're not using, none of the family members have wills, which is very common. Most people do not have wills. But when we don't have a will, we rely on intestate succession. So this is the set of laws, and every state has this set of laws. It varies from state to state. So the intestate succession laws in South Carolina will be different from the ones in Virginia and North Carolina, et cetera. But in North Carolina, and that's what these are, in North Carolina, it's pretty straightforward at the beginning. If you have a child but no spouse, it goes to your children. Spouse but no descendants or parents, the spouse inherits everything. It starts getting complex when you have different mixes of survivorship. So if you have a spouse and one child is descendants of one child, then they split it half and half. It gets more complicated on the next level. If you have a spouse and multiple children or multiple descendants, then it's 1/3 to the spouse and 2/3 to the children, the descendants, and so on and so on. And even involves a scenario where your spouse and your parents can inherit your real estate. And just to make sure we're on the same page, we're not talking about marital property. We're talking about property that an individual owns a share from separate from their spouse. This is how it could flow. And other things that we should think about in heirs property that the laws dictate is that the way that these family members own the land is called tenants in common. Remember, before a married couple owned it as tenants by the entirety. It meant specifically for married people, if you own land together, there's a right of survivorship. With tenants in common, we don't have that same right of survivorship. And it's a separate type of a bundle of rights. It requires it requires unanimous decision making. It requires that everyone contribute what they're responsible for, proportional to their share. It allows people, the owners, to seek division of the property, so physical division of the property or transfer, either voluntarily or through the court system. We have a set of laws in North Carolina and every state called related to partition actions. So every tenant and common owner has legal right to go to court and say, hey, I own a 1/4 share in this 40 acres, and I want my physical acreage. And the clerk would be the one that decides that, not the family members. They could also say to the clerk, hey, we have this land. I don't think that it can be physically divided. Therefore, I'm requesting that you force the sale of it. And that's where we get into land loss, is where the clerk, because the property cannot be physically divided, has determined that the property has to be sold at auction. And they're required to sell it at auction if it can't be physically divided. There are other challenges in addition to the legal structure. It can make it really difficult from a social perspective. You can become owners with other people you would never imagine owning real estate with. You might have a different connection with the property, or you may have no connection at all. There might be intergenerational social challenges that come into play, where there's an expectation to defer to the elders, but if you have the same legal rights and the same voting, that's not something you're required to do. And it also can create a financial hardship wherein you have people who have the ability to pay, but you have people who don't have the ability to pay. And so some folks may leverage their own funds to cover other people's shares, but then not get recuperated or reimbursed for that. And so it can create conflict around that. The way that we make it work looks pretty simple. What I've laid out here are 4 steps for an approach, and they are in order. And this is the ideal. The ideal is that the starting place to address the legal issues begins with the family tree. So not beginning with the lawyer, but instead beginning with building a family tree. And that's because the ownership is transferring from individual to individual through inheritance. And we don't have deeds to reflect that. Instead, we'll look at the family tree and then, in combination with the laws and a little bit of math, determine who owns what and what their shares are. So the family tree is essential. And when I was doing this work in my law practice, for me, that was a starting point, that you shouldn't start working with a lawyer until you have a comprehensive family tree that goes from the original owners to the current, most recent generation of family members, and include the date of death, where people died, and who their immediate family members were. Then once you have a comprehensive family tree, that's when you go to an attorney to perform a title search. And the title search refers to a process in which an attorney, often with the help of paralegals and other professionals, an attorney will trace the ownership of the property from the original deed where the property came into the family to the most current generation of owners. And in doing that, they are using both real estate law, estate law, perhaps other areas of law, to identify who inherited and what they inherited and what did they pass on. It's pretty complex, and so I think it's really important when you're engaging an attorney for a title search to have a clear understanding of what your goals are, but also have an idea of what your tolerance level is for the work that has to be done and the cost of the work that has to be done. And perhaps you can start off with a consultation in which you're saying to the attorney, please give me 5 hours of your time to begin a title search, and at that 5-hour threshold, we're going to check in and you're going to tell me what it's looking like and whether I can move forward with my goal or whether something else needs to be considered or just pivot altogether. And that's really important because the title search alone can cost thousands of dollars. And it's really useful to have an understanding as you go along of whether or not your goal is achievable. But let's imagine for our family that they've confirmed who the legal owners are. We've identified our 16 owners. The next step would be to have discussions with the other owners about what to do with the property, and then change the ownership structure by putting the ownership of the property into a single entity owner, such as a trust or LLC. Of course, you could maintain the current situation, which many people do, and that has lots of implications. You could also enter into a contract with owners. Again, it would require having legal confirmation of who the owners are, but you could have a contract in which you set up some terms about who's responsible for what, how the land could be used, etc. You could, of course, divide the land, but when land is physically divided, the value from an economic perspective and even a natural resource perspective likely decreases significantly. And then, of course, you could sell the property, and you can do that either voluntarily or sell through or seek a court action, which can be very costly but also very painful. There are a lot of initiatives out there that are supporting heirs property owners, including the program that I have the honor of working with, the Sustainable Forestry and African American Land Retention Project. The Land Loss Prevention Project is also another organization that has been working with landowners who have a lot of different issues, including heirs property. There's model legislation that has been introduced and accepted across the country. So model legislation basically is where a bunch of smart lawyers get together and they draft up some legislation that they think can address a particular issue. And so that happened with respect to heirs property. And you may have heard the godfather of the Uniform Partition of Heirs Property Act, Thomas Mitchell, was just awarded a MacArthur Genius Grant. And I think that's significant because I think it's bringing a lot of shine to this issue and the significant work that has been done. So that's another, we haven't adopted it in North Carolina. We have a coalition of folks who are working on that for next year. So if you're interested, please hit me up. And then the Farm Bill 2018 is the first time a Farm Bill has actually made provisions for heirs property owners. Historically, heirs property owners were not able to get farm and tract numbers and other services because they couldn't prove ownership. And this Farm Bill has made clear what documentation they can provide in order to get the farm and tract number and to get services. So that's really significant. There are other benefits and incentives to addressing the legal challenges. Forestry and agriculture. I know forestry is part of agriculture, but those are areas. Conservation, carbon, creating legal standing to address environmental justice issues. So again, if you can't prove that you own property, if you have a legal claim against your neighbor, let's say you are next to a hog farm, if you can't prove that you own the property, you don't have the legal standing, as we call it, to actually go to court and fight that. And so addressing the legal issues is really important to be able to address broader issues. So what can you do for heirs property? I think it's important to appreciate the history and contributions of family-owned land as heirs property. I think it's also important to expand, for organizations like Coastal Land Trust, to expand priority protection areas and your organization mission. So identifying the potential for land loss because of this complex issue and creating a priority around how you can address that. Also for those service providers and conservation organizations, providing technical assistance to heirs property owners. Just because you have complicated legal issues doesn't mean that you can't learn about the natural resource characteristics of your land and work on optimizing those. You can partner with other organizations to address the legal issues. You can create asset maps. This is both on individual and group level, and I'll show you what an asset map looks like in just a second. And again, for organizations, you can develop funding specifically for land owned as heirs property that will support addressing the legal issues so that they can get into conservation initiatives. And I'll end with this asset map. An asset map is a visual inventory of the various resources that are available for a particular issue or objective. In this case, we're thinking about heirs property resources in a particular county, or maybe it's a particular region. And you break it out into categories. And the reason why I bring this up is that it may feel overwhelming to try to address this big issue. And I think to the extent we can highlight what all the resources are available for those landowners and for our own land, that we might feel more confident and motivated to take action. So you would organize it by the area and the topic, and then you would have subcategories like legal, institutions, government, business organizations, and even the land itself. And then you would identify the resources for each of those categories that are available in the specific geographic area. So that was a whirlwind. I'll catch my breath, and Stephanie or someone else, I wonder if there are any questions or.
Wow, that was a whirlwind. Thank you. I'm wondering if anyone has questions for Mavis. We have time to ask questions and do some answers. So feel free, if you do, to unmute and ask now. if you do. And Mavis, did you want to do the third polling question, or do you want to wait, do that in a second?
Oh, yes. I forgot about the third question. So the third question, do I need to share my screen for you to do that? Or okay.
Nope, I got
so
it.
the third question is, no pressure, but if you don't have an estate plan or a succession plan for your land, do you feel motivated now to seek one? Okay. Some folks are responding.
Oh, sorry, I clicked.
That was more. Oh, what happened?
Oh man, I blew it. I'm sorry.
Well, it sounded like there was some interest. Some people were motivated by what was shared to get an estate plan. I mean, technically all of us have an estate plan. You either have one that's customized for your circumstances and your loved ones, or you have the government plan. Any other questions?
Heirs Property.
I've got a question.
Oh, go ahead. Go ahead.
Sorry. Chris Canfield has brought to Land for Tomorrow a proposal around getting an amendment to the North Carolina law that mirrors more what has in South Carolina, that the people who are actually living on the land have more standing in a petition than those who don't. And I'm sure I've bobbled that because I'm not a legal expert by any stretch of the imagination. Can you elaborate a little more on that, Mavis? That is it really, are we seeing where you've got these people coming in from, outside of that area, insisting on petition and not talking to the other family members?
Yeah, so the law that you're referring to, so all states have a legal proceeding that allows a tenant in common, so it's that specific bundle of rights, and it may apply to other bundle of rights, but for the purpose of heirs property, that allows a co-owner to petition the court to physically divide the land. If the court cannot physically divide the land, the court has to force the sale of it. So this doesn't, under the standard, the traditional law, even if it's family-owned land, because any family member has the right to transfer their share to a third party, we usually see the partition actions coming into play and resulting in loss or fractionalization when you have a third party who purchases or acquires a share of a family member and then uses the legal rights that owners have to pursue for sale. And what I've seen in my practice before was, for example, I had a family where there was probably 72 owners, and a commercial farm next door purchased 1 or 2 shares. So you had 70 were family members and 1 was a farm, a big commercial farm. They then had the legal right to pursue a partition action, and they did. And they did it in a county that, I'm just judging, a county that's not very diverse. And it seemed clear in looking at the proceedings that the clerk and the petitioner's attorney knew each other well, because the clerk then appointed the petitioner's attorney as the person tasked with doing the sale. So there's like other issues in addition to the law. There's also what happens. I don't think that was legal, but anyway, what happened was that family was in a point where they were going to lose their property, and they reached out to me 2 weeks before the hearing. Another example of this is in Raleigh. I had talked to a man who his father had 5 children. His house near downtown Raleigh went to the 5 children. One of the children passed away and left 5 heirs. So you went from 1 owner to 9, and that sibling's children lived in another state, had nothing to do with the property, and one of them sold their share to a LLC, who immediately did the same thing that the commercial farm did. They saw the action, and in that case, you can't physically divide a house. There wasn't enough acreage to divide the land, and so it's an easy shot. All they need to do to get it as close to downtown Raleigh property is petition the court for a forced sale. And so this act that you're talking about, the legislation, what it does is it provides an extra level of due process rights. And it doesn't harm people from getting shares in family property, third parties, but instead it allows the families to at least maintain some of the economic value because they get the first right of refusal. And if they can't buy it, the property has to be sold for fair market value. Traditional auctions, you're not necessarily going to get fair market value, and likely it's going to be very low, but it's still high enough that the family can't outbid that third party. So it's a very important legislation. I think it would be really great for North Carolina, particularly with the Farm Bill, because the Farm Bill has those provisions, and it's specific in states that have adopted this legislation, what's required. For states that haven't adopted the legislation, it's very different and will be a bigger burden, a bigger obstacle for them to get the farm and tract number and get those necessary services.
So is the North Carolina Bar Association supporting this, or where are they? Because the committees in the General Assembly listen to the bar. Yeah.
Well, please, send your positive vibes and energy to the bar. I don't know where they stand yet. I know that in other states, it has been critical to have the support of the bar. The reality is a lot of lawyers who work with those third parties who buy heirs property shares, it hits their bottom line because it would actually make it really difficult for them. It could make it really difficult for them to get property for cheap or, highly desirable property. It could make it more costly and difficult for them to do. And so getting the support of the bar is a very nuanced endeavor. And we have folks in the coalition who are kind of liaisoning with, is that a word? Liaising? Doing the back and forth with them. But I don't know that we have it yet. The great thing was that the Virginia bar was instrumental in Virginia passing it, and they've even taken it a step further in developing a pro bono program for heirs property owners.
Thank you.
Thank you, Catherine, for your question. There's a question from the chat, and I'll just read it. Say I inherit property that is held in joint tenant in common with a married sibling, and they divorce. Does the ex-spouse hold any rights?
So you own heirs property with a sibling who's married and their spouse, they've gotten a divorce. Does their spouse get a share? That's a great question, and I'll even broaden the question to include creditors. So I don't do family law, and I actually can't answer the question. I don't know if I can answer accurately. I will say that as tenants in common owners, each owner's creditors are privy to their share. So that's one issue that comes up. As far as could that separate property be included in a divorce, I don't feel confident enough in my family law knowledge to know if they would be. I think it would depend on when they became an owner and how the state treats separate property, separate real estate owned. There may be some implications for that. I don't think there are, but there may be. But using spouses as an example, I had a case, one example, there's multiple. I had a case where the property went from the parents to the 6 children, and then three of the children died. 2 of them had wills that stayed in the family. The other child, these are adults, died. They were survived by their spouse who remarried, and then that spouse died. So his share went to his second wife, and then she died, and her share went to her kids. So these are people who literally have never met their original owners, don't even know them, but now they own property with the owner's descendants.
Wow, that's amazing. And a previous comment in the chat was the exponential effects of the next generations is just incredible. There's another question in the chat. If 3 individuals own heir property together, and one of the owners is married but dies with no children, then who inherits that person's property?
Based on what you described, and as long as they didn't have a will, then it would go to their spouse. So you've described my own circumstances. My siblings, my brother and sister and I inherited from our parents, and we own property together. And I begged them, it's kind of ironic, I work on this issue, I begged them to put our shares into a trust or LLC up until my brother's wedding. day. And he had agreed, he just never signed it. And so now he's married, and his wife, even if he still wants to put it in a trust or LLC, his wife still has to sign the deed. Yeah.
Boy, you picked a complicated one. Oh, goodness. There are a couple of comments from Facebook just saying thank you very much, that this was a great presentation, that it was an opportunity to learn a lot. So we do thank you for your time and for your expertise to share with us today, Mavis.
Thank you.
Yeah.
Thank you.
Today is the 16th. Next week is the 23rd. And unfortunately, we had a cancellation of our scheduled speaker. So I'm still working to schedule something. So please watch email and Facebook in the coming week, because if we get somebody if we can find somebody, we will have lunch lecture next week. So hang in there with us on that. And then on October 30th, John Carpenter with the North Carolina Wildlife Resources Commission will be with us to talk about the endangered red-cockaded woodpecker. So like the day before Halloween, that's a pretty scary topic to be talking about an endangered animal. So y'all join us for that and learn about the red-cockaded woodpeckers. And if you would like to see what else is coming up, go to coastallandtrust.org/events. And as we schedule lectures, we do put them up on that website. So they are there for you to learn about. Okay, guys, thank you so much again for joining us today for Little Lunch Lecture. Hope to see you next week, but if not, see you on the 30th. Everybody have a great weekend. Thanks. Thanks again, Mavis. Bye.